This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. Out of the Middle District of Pennsylvania, we have an update in a Liebowitz case. I'm not going to spoil it for you. Just listen up, get your popcorn, and we'll see how Liebowitz managed to screw up yet another case. This is the Adlife Marketing and Communications Company case versus Karns Prime and Fancy Food Limited. Before the court is defendant's motion to dismiss for failure to prosecute pursuant to Federal Rule of Civil Procedure 41B. Various other motions are also currently pending, and the judge lists those and says they will be denied as moot. Plaintiff initiated the above-captioned action on September 23, 2019, by filing a complaint in this court, the U.S. District Court for the Middle District of Pennsylvania, asserting a claim of copyright infringement in violation of the Copyright Act. Defendant filed an answer, after which the court scheduled a case management conference. At the case management conference on February 3rd, 2020, the court set a close of fact discovery deadline of August 4th, 2020, and the parties agreed that the final date for amending pleadings would be March 1st, 2020. On July 27th, 2020, Plaintiff's counsel Richard Liebowitz filed with this court a copy of a June 26, 2020 opinion and order from the U.S. District Court for the Southern District of New York, in which Mr. Liebowitz was severely sanctioned for a history of egregious, dilatory conduct, including failure to comply with court orders and false statements. The sanction order included a directive requiring Mr. Liebowitz to file a copy of the opinion and order on the docket in any of his pending cases, including this instant action, as well as to serve a copy on all of his clients, including plaintiff. On August 4th, 2020, discovery closed. Subsequently, defendant submitted a status report in which it averred that plaintiff had been non-compliant with discovery requests until finally producing approximately 300 pages of discovery after the deadline had passed. Defendant further averred that plaintiff failed to respond or in any way communicate with defendant regarding the status report, despite the court's February 3rd, 2020 case management order, which directed the parties to meet and confer following the close of discovery and submit a joint status report. This is a common procedure with courts, is to order a meet and confer, meaning the parties literally have to talk to one another by court order. It's a way to make the parties talk to one another, and then they have to jointly file a status report. When the parties disagree, you just say, okay, I disagree. So plaintiff is going to write their paragraph and defendant is going to write their paragraph, and they're both going to appear in the joint status report. But you have to do it, and you have to do it together. It's kind of like the teacher putting two students who don't want to work together. You know, you two are going to work together and you're going to come up with something, and I don't care how good it is, but you're going to come up with something and you're going to work together. And usually that means something good will come out of it. They'll figure out how to work together, which is something humans sometimes have to be made to do, and they will then submit their joint work. Defendant then filed a motion for summary judgment on August 19th, again 2020. The court held a post-discovery status conference with the parties August 24th. During this conference, Mr. Liebowitz acknowledged for the first time that he was not admitted to practice law in the Middle District of Pennsylvania, and averred that he would seek special admission pro hoc vice for this time only by the end of that week. In light of these representations, the court stayed the above-captioned action pending the entry of an appearance of counsel for plaintiff who is qualified to appear on behalf of plaintiff. Mr. Liebowitz never sought special admission, and this action remained stayed. Ultimately, on October 30th, 2020, defendant filed the instant motion to dismiss for failure to prosecute pursuant to Rule 41B, along with a brief in support, in which defendant avers that the conduct of plaintiff and plaintiff's counsel throughout the litigation of this action, including the lack of any attempt to seek special admission or substitute qualified counsel after the court imposed a stay, has severely prejudiced defendant, and that dismissal is the only appropriate sanction. On November 12, 2020, James H. Freeman, also of the Liebowitz law firm, filed a petition for special admission and, along with new counsel Mark G. Windauer IV, filed a brief in opposition to defendant's motion to dismiss the following day. On November 24th, 2020, plaintiff's counsel Joseph A. Doon entered an appearance on behalf of plaintiff. The following day, defendant filed a reply brief in support of its motion to dismiss. Attorneys Liebowitz, Freeman, and Wendauer filed a motion to withdraw as counsel. And Mr. Doon filed a motion for leave to file a supplemental response to the motion to dismiss on the basis that plaintiff allegedly did not authorize the opposition filed by Mr. Freeman and Mr. Wendauer. The request for leave to file a supplemental response was not concurred in, and plaintiff never filed a brief in support of the motion. So an important thing to note there, besides all the back and forth, was that Liebowitz, Freeman, and Wendauer had entered their appearance. Freeman and Wendauer apparently did it through the court's admission process. Liebowitz entered his appearance by filing documents, but he apparently did not follow the court's admission procedure, which is a violation of the court's rules. So then they file a motion to withdraw as counsel, which is only a motion. The judge can deny the motion. You don't automatically get the right to withdraw. Many times in many situations, the judge will grant the motion to withdraw, but not all the time. And so the judge just goes on and doesn't say, I granted the motion to withdraw, and then. Instead, the judge says, it appearing that plaintiff had finally secured qualified counsel, the court lifted its stay on December 4th, 2020. Following 2 requests for extensions of time to respond to the pending motion for summary judgment, plaintiff filed a response on January 26th. So the judge says nothing about granting the motion for the counsel to withdraw. So the judge is currently, according to this, still holding Liebowitz and his firm and the local counsel to complete the summary judgment motion process. Neither defendant's motion for summary judgment nor plaintiff's motion for leave to file an amended complaint are currently ripe for disposition. However, defendant's Rule 41B motion to dismiss has been fully briefed. Accordingly, the court will now consider that motion. Federal Rule of Civil Procedure 41B allows for dismissal of an action for failure of the plaintiff to prosecute or comply with these rules or order of court. When determining whether to dismiss an action for failure to prosecute, the court must balance 6 factors: the extent of the party's personal responsibility, the prejudice to the adversary counsel caused by the failure, a history of dilatoriness, whether the conduct of the party or attorney was willful or in bad faith, the effectiveness of sanctions other than dismissal, the meritoriousness of the claim or defense. Not all of the factors need to be satisfied to dismiss a complaint, and those are from the Powless v. State Farm Fire and Casualty Company, a Third Circuit 1984 case. As an initial matter, the court will address plaintiff's motion for leave to file a supplemental response. Local Rule 7.5 provides that within 14 days of the filing of any motion, the party filing the motion shall file a brief in support. If a supporting brief is not filed within the time provided by this rule, the motion shall be deemed to be withdrawn. Local Rule 7.5 provides that a supporting brief need not be filed in support of a motion in 3 limited circumstances: in support of a motion for an enlargement of time, if the reasons are fully stated in the motion; 2, in support of a motion which has the consent of all parties, if the reasons for the motion and the relief sought are stated in the motion; and 3, in support of a motion for appointment of counsel. In the present case, none of these limited exceptions apply. Defendant did not concur in plaintiff's request to file a supplemental response. However, plaintiff never filed a brief in support of its motion as required by the rule. Accordingly, the court finds that plaintiff's motion and exhibits are not properly before it and will deem the motion withdrawn in accordance with Local Rule 7.5. In support of the motion to dismiss, defendant begins by noting that plaintiff is a sophisticated litigator of copyright disputes that has a judicially noted, long-standing relationship with Mr. Liebowitz, despite his egregious history of litigation misconduct that has resulted in repeated public rebuke from judges across the country. Defendant submits that plaintiff has been represented by Mr. Liebowitz in over 40 proceedings since 2018, despite the fact that Mr. Liebowitz has been the subject of numerous and severe severe sanctions during that period, which the court notes includes, but is not limited to, the June 26, 2020 opinion and order from the Southern District of New York, and the fact that Mr. Liebowitz has been barred from practicing in the U.S. District Court for the Northern District of California for filing cases despite not being admitted to practice there. See also another Adlife marketing order dismissing the complaint, imposing sanctions, and noting that Adlife's continued use of an attorney who has little respect or knowledge of local procedures, violates court orders, lies under oath, and is continuously sanctioned for frivolous lawsuits. Back to the instant motion. Accordingly, defendant argues that plaintiff is complicit in the conduct of Mr. Liebowitz and should be held responsible for the actions of its counsel, whom it knew had an extraordinary record of misconduct. Defendant further argues that it has been prejudiced by plaintiff's disregard for the case management order and indifferent to the prosecution of this matter. Defendant notes that throughout the discovery period in this action, it attempted to obtain information from plaintiff by propounding 2 sets of interrogatories and requests for production of documents, but plaintiff refused to meaningfully respond and asserts that plaintiff's conduct in serving defendant with the only substantive information produced by plaintiff since the lawsuit was filed after the close of discovery denied the defendant the opportunity to conduct follow-up discovery in the form of requests for admissions, depositions, etc. on plaintiff's discovery, and this is highly prejudicial to defendant on its face. In addition, defendant notes that it invested in the filing of a motion for summary judgment only for the case to be stayed due to plaintiff's conduct, and that this matter has been in litigation for more than a year with virtually no progress made toward an ultimate disposition on the merits, but with significant expense to defendant. With respect to the remaining Paulus factors, defendant notes that in addition to plaintiff's conduct in this case, plaintiff has also failed to prosecute other cases in this court before the Honorable Chief Judge Jones. See Adlife v. Mussers. The court notes that this case settled just prior to the filing of the instant motion. However, plaintiff also has another case pending before the Honorable Chief Judge Jones, in which Mr. Liebowitz has not filed a motion to withdraw and allowed the case to sit idle after an entry of default on March 20th, 2020. And once more points to plaintiff and plaintiff's counsel's epic history of litigation misconduct, marked by references to perjury, fraud, and dilatory practices. Defendant further submits that there are no alternative sanctions that will provide defendant with the relief to which it is entitled because the prejudice defendant has suffered would remain unchanged, and because plaintiff and plaintiff's counsel do not institute copyright litigation with the intention of resolving the claim on the merits, but rather to extract a settlement. Defendant also notes that Mr. Liebowitz has been subjected to virtually every sanction imaginable, including extensive fines and costs, and disbarment or recommended removal from the rolls of multiple courts, none of which seem to have impacted plaintiff's decision to continue to retain Mr. Leibowitz's legal services. Indeed, the court notes that Adlife's complaints have been dismissed by other courts in connection with Mr. Leibowitz's misconduct, and yet that does not appear to have impacted the professional relationship between Adlife and the Liebowitz law firm. Finally, defendant asserts that its defenses to this action are meritorious, as more clearly defined in its motion for summary judgment. In response, plaintiff's arguments are limited. Plaintiff provides no explanation for its conduct regarding discovery production or its failure to comply with the court's case management order, instead asserting that the period in which this action was stayed was a brief administrative delay, that defendant cannot show prejudice by a mere 3-month delay, that there is minimal history in this case of dilatoriness, that defendant has failed to show that a 2 to 3 month delay complained of here was the result of bad faith, that alternate sanctions have not been considered and are not otherwise appropriate, and that plaintiff's claim is meritorious. Upon review of the record before the court, the parties' arguments, and the applicable law, the court will dismiss plaintiff's complaint pursuant to the Federal Rule of Civil Procedure 41B. As an initial matter, the court notes that it is well aware of the procedural history of this action, as discussed previously, and considers the totality of plaintiff's conduct in prosecuting this case, not only the 12 weeks in which the court stayed the matter pending the appearance of qualified counsel. Further, the court acknowledges that Rule 41B dismissal is a severe sanction that is only appropriate in limited circumstances. Nonetheless, the court finds dismissal appropriate here. Turning to the Paulus factors, the court first considers the extent of plaintiff's responsibility in this matter. In assessing this factor, the court is cognizant of the differences between Mr. Liebowitz's responsibility as plaintiff's counsel and plaintiff's responsibility, and the fact that the Third Circuit has emphasized imposing sanctions on disreputable attorneys rather than their clients, absent an indication that the client was aware of the attorney's conduct. However, the personal responsibility criterion does not aim to protect all innocent victims from dismissal of a case, and corporate plaintiffs have previously been held personally responsible for the actions of their counsel. Further, in evaluating the history of plaintiff and Mr. Liebowitz's conduct in this case, as well as the relationship between plaintiff and Mr. Liebowitz in general, the court does not find that this is a case of an innocent client suffering the sanction of dismissal due to dilatory counsel whom it hired to represent it. Rather, as discussed in more detail by the United States District Court for the Northern District of New York, quote, "The court notes Adlife's continued use of an attorney who has little respect or knowledge of local procedures, violates court orders, lies under oath, and is continuously sanctioned for frivolous lawsuits. Adlife is known for being litigious and has been represented by Liebowitz in at least 41 proceedings since 2018, and then it goes on to start listing them. Several of Adlife's cases were voluntarily dismissed shortly after a court request for registration, copyright registration, verification, text or minute orders for failure to comply with local laws, or a show cause order for lack of proper service." Did they list some of these? This is of no surprise, as Liebowitz is known to voluntarily dismiss suits that are subject to dismissal when it is clear they are in hot water. In over 700 cases Liebowitz has filed since 2016, over 500 of those have been voluntarily dismissed, settled, or otherwise disposed of before any merits-based litigation. In most cases, the cases are closed within 3 months of the complaint filing. Now, I'm not one to try and speak good about Richard Liebowitz here, but in other cases that I've seen, courts who have decided that dismissing lawsuits before they reach merit-based outcomes, when courts decide that that's a kind of a bad thing without knowing why, appeals courts have said you can't do that. Appeals courts have said that settlement is a perfectly okay outcome, and filing a copyright case and having the defendant realize that it's a bad deal to go forward with the defense, that it's either too costly, or that maybe they actually have no merits-based defense and therefore have to settle, that's an okay thing to do. I don't like that. I would like to see every innocent defendant be able to litigate, but if a defendant comes to me and says, "I'm guilty as heck, but I want to litigate this case," I'm going to say, okay, I'll litigate for you, but here's what's going to happen. Like, they're going to get to ask you questions under oath. They're going to get the right to discover evidence. If any of that evidence shows that you are, in fact, liable for the offense, the judge is probably going to be convinced. And then I also talk to my clients about not lying under oath. This is not a read between the lines situation. We don't want to lie under oath. That can make a case way worse, and it can get attorneys disbarred. So that, not a situation where, I want you to lie under oath. No, we don't want clients to lie under oath just to try and win a case. We either have a meritorious defense and you defend yourself, or you don't. The limbo, or the sad truth, is that sometimes you have an innocent defendant who can't afford to defend themselves. And I do my best to work with my defendant to figure out how we can afford to defend. Sometimes, though, I admit that some defendants can't afford to defend themselves, even though they're claiming innocence. Back to this case, in addition, even if the court were to accept that plaintiff had no knowledge of the numerous dismissals of its own cases brought by Mr. Liebowitz, or sanctions levied against him prior to the conduct in this case, at a minimum, plaintiff must have become aware of its counsel's egregious history of misconduct after being served with the sanction opinion and order of June 26th from the Southern District of New York. And that's why the court did that there. In fact, a mere 6 days prior to this court staying the instant action, the Northern District of New York dismissed the above-cited, I think it was Adlife case, in addition to levying sanctions against Mr. Liebowitz. Nonetheless, plaintiff continued to retain Mr. Liebowitz to represent it in this action and others until nearly the end of November 2020. Regarding the specific conduct of Mr. Liebowitz filing multiple cases in this court on Adlife's behalf, despite not being admitted to practice in the Middle District of Pennsylvania and without seeking admission pro hoc vice, the court notes that an order of disbarment was entered against him in the Northern District of California on October 7, 2019, for the exact conduct demonstrated here, filing numerous cases in a district without being admitted to practice. But then I guess the court isn't going to disbar Richard Liebowitz from the Middle District of Pennsylvania. I don't know why it stops there. Reviewing this history as a whole, the court can only conclude that plaintiff bears responsibility in this matter as a corporate party that deliberately engaged the services of an attorney and law firm with a well-documented history of serious misconduct. In the alternative, the court finds that the remaining Paulus factors support dismissal regardless of its determination regarding plaintiff's responsibility. Examining the second Paulus factor, the court agrees with defendant that it has been prejudiced by plaintiff's conduct and the delays in this matter. Defendant has been attempting for over a year to defend an action in which plaintiff was non-compliant with court orders and non-responsive throughout months of discovery, only producing substantive documents after the discovery deadline, and in which the allegations at issue have not even been clarified. For example, the complaint in this action, as well as counsel's representations regarding the same, indicated that there were 22 copyrights and 36 images at issue. However, in opposition to the instant motion, plaintiff asserted for the first time that it is the rightful owner of 52 copyrighted photos, and in the most recent motion for leave to file an amended complaint, asserted that this dispute involves a total of 62 images and approximately 350 uses. Neither plaintiff nor plaintiff's counsel has ever provided an explanation for this conduct. Instead, plaintiff's argument against this factor in its opposition is a total of 4 sentences that assert in a conclusory fashion that defendant cannot show prejudice by a mere 3-month delay in this lawsuit. However, prejudice for the purpose of Paulus analysis does not mean irredeemable harm, and the burden imposed by impeding a party's ability to prepare effectively a full and complete defense is sufficiently prejudicial. Accordingly, the court finds that defendant has been prejudiced by plaintiff's non-compliance with discovery obligations and lack of clarity surrounding the allegations in this case, which have impeded defendant's ability to mount a defense, as well as by the delays in briefing of its still pending motion for summary judgment. Examining the third and fourth factors, a history of dilatoriness and whether the party's conduct was in bad faith, plaintiff not only filed the instant action through counsel who was not qualified to practice before this court, but was non-compliant with discovery obligations and the court's case management order, and failed to secure qualified counsel to enter an appearance in this action for 3 months after Mr. Liebowitz stated that he would file for special admission within days of the court's August 24th status conference. Plaintiff has not provided an explanation for this conduct, and viewed in light of the fact that Mr. Liebowitz and plaintiff have a well-documented history of similar actions before other courts, and indeed that Mr. Liebowitz has been specifically sanctioned for this conduct, the court can only conclude that these actions were undertaken willfully and in bad faith. The court acknowledges that it must consider alternative sanctions before dismissing a case pursuant to 41B. The court is specifically authorized to impose on an attorney those expenses, including attorney's fees, caused by unjustified failure to comply with discovery orders or pretrial orders. However, the court does not find that alternative sanctions would be effective in this case. As discussed throughout this memorandum and detailed even more thoroughly in the June 26th opinion and order from the Southern District of New York, Mr. Liebowitz has been sanctioned time and time again, both monetarily and non-monetarily. Mr. Liebowitz has been required to pay fines, attorney's fees, and costs to the tune of hundreds of thousands of dollars, has been ordered to complete ethics courses, referred to disciplinary committees, and has even been barred from practice in at least 1 district, now 2, I think, and been recommended for removal from the rolls of courts in others. Mr. Liebowitz and his firm do not appear to have been deterred by any of these sanctions. Indeed, it has been suggested that there may be no sanction short of disbarment that would stop Mr. Liebowitz from further misconduct. Despite this long history, which includes representation by Mr. Liebowitz and his firm in cases where he was sanctioned, plaintiff continued to utilize Mr. Leibowitz's legal services until late November 2020. Accordingly, it seems apparent that alternative sanctions, especially the imposition of fines or costs, would be ineffective. Regarding the sixth palace factor, the meritoriousness of the claim, the court notes that a claim or defense will be deemed meritorious when the allegations of the pleadings, if established at trial, would support recovery by plaintiff or would constitute a complete defense. To establish a claim of copyright infringement, a plaintiff must establish 1. Ownership of a valid copyright, and 2. Unauthorized copying of original elements of plaintiff's work. However, a plaintiff is only entitled to actual damages determined by the loss in the fair market value of the copyright, measured by the profits lost due to the infringement, or by the value of the use of the copyrighted work to the infringer, or statutory damages if the alleged infringement commenced after the copyrighted work was registered. Plaintiff's complaint and associated submissions include no information regarding loss to plaintiff or when its allegedly infringed images were registered. Accordingly, the court finds this factor is neutral. In light of the foregoing, the court finds the majority of the 6 palace factors weigh heavily in favor of dismissing this action pursuant to Federal Rule of Civil Procedure 41B. For the foregoing reasons, defendant's motion to dismiss will be granted, and plaintiff's motion for leave to file a supplemental response will be deemed withdrawn. The remaining pending motions on the docket will be denied as moot. An order consistent with this memorandum follows. So yeah, there is another way that Liebowitz managed to screw up a case. Don't be a Liebowitz. Yeah, I mean, I don't even need to go over the million things that's wrong with this. Getting into appearing in court where you're not even admitted, not following the procedure for admission when you're called out on it, not responding to discovery requests on time, not following up with all of that as quickly as possible with a meritorious explanation. All of the other things, getting removed from the rolls of the Southern District of New York, getting disbarred from the Northern District of California, getting sanctioned in all those other cases, having to, I think it was Jesse Furman's order, having to file Jesse Furman's order with all of the other courts and clients and everything. All of these things should have been individually enough to motivate Liebowitz to get his act together, figure it out. If he's taking too many cases, he has to take fewer cases. I want to make a video about this next point, but I also, before I make this next point, I want to disclaim what I'm saying. I have no evidence that Richard Liebowitz is committing some other kind of fraudulent activity or misconduct. However, there is a well-known situation, generally speaking, that lawyers can get themselves into that's called the law firm or the lawyer Ponzi scheme. It's not, certainly there are real Ponzi schemes. That's not what I'm talking about. And again, I'm not talking about Liebowitz specifically here. I'm saying here's me speculating on what could be happening. What ends up happening is, like a Ponzi scheme, you take on all these clients and you charge them this money and you say, I can help you fix all of this, and I'll either keep some of the money on contingency or you'll pay me a flat fee up front or something. And then the matters get more complicated than you thought, and they cost more money than you thought, but you can't get the money from the client because that wasn't your agreement. You said you were going to do it on contingency. Maybe your contingency isn't recovering the amount of money you thought it was going to recover. So now you don't have the amount of money you thought you did. Meanwhile, you have business expenses and student loans and personal expenses and your lifestyle and court costs, and you're putting in all of your time as well. You know, not just time is money, but you only have so much time. It's a scarce resource. And you do all of this, and it's just not enough to get you through all of these cases. And then, wait, you still have more business coming in, so I'll just raise my rates or take more money from new clients, and then I'll use that new money to pay for the problems that were with the previous cases, because, you know, in my head, I'm not seeing how the same problems can happen if I don't fix what I'm doing wrong. So I do the same thing with the next round of cases, use the next round of cases to pay off the first round of cases. And then I've got problems with the second round of cases. So I need to take on a third round of cases to pay for the second round. And there's still things from the first round of cases. And so what this ends up happening is eventually it catches up, and it looks very much like when a Ponzi scheme catches up with someone like Bernie Madoff, and it's just, you realize the whole thing was a giant fraud. Again, I'm not saying that that's what Liebowitz is doing, but from the outside looking at what's happening, it seems like he has overspent his time and money and screwed up enough cases that now he owes money, and he owes time, and he owes court appearances, etc., and he owes more than he has to catch up. And so the only way to continue would be to go forward. But now the courts are starting to cut off the fire hose of business that he has been taking. So unless he figures out how to put out the fire himself, it's going to catch up with him someday. I am still baffled that this has not caught up to him earlier and with much harsher penalties. I feel like other attorneys, other situations get much harsher penalties for conduct that is either, well, not nearly as egregious in quantity, but someone will get suspended or disbarred from the entire practice of law for one screw up that might be at the same level of what Liebowitz did. But Liebowitz, for some reason, does not get suspended or disbarred from the entire practice of law, even after all of this misconduct. So it's real. I almost wish that I could cite this. Like if somebody was in the process of being disbarred, they could just say, but Liebowitz, and the state bar would have to go, oh yeah, you're right, we didn't do it to Liebowitz, so we can't do it to you. But I don't think that's how the standard works. I don't think you can say, but you didn't punish that guy, so you can't punish me, unless it is like directly applicable. So it continues to be an unfair and unjust world, but at least it's starting to catch up with him. Let me know what you think of this latest round of Liebowitz shenaniganery yourself in the comments below. Thank you for watching. I'm Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite legal news and education channel here on YouTube. You can also find us on Floatplane and on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Our channel is community supported by your monthly financial contributions on patreon.com/ljfrench, sponsors.com/law, through YouTube memberships, and through Floatplane subscriptions. Thank you to the following $50 plus supporters in the month of March: Joe Tyson, John Steele, Gavin Barnard, Eevi, Spirit Bear, Andy, Benjamin Hitov, Ugly Grill, Rudolph Bescherer Jr., Brandyn Abel, Torpedan, Cassandra Curran, Sovereign Tittizen, ShadowTycho, RDHDragon, and Earthbound Star. And thank you as well to the $5 plus supporters who are scrolling on your screen. I hope everyone has a great week. I will see you in the videos that drop. I love you all. Bye.
I'm not a cat.